Welcome to SPR IES Academy. In our today's video lecture, we are going to see about the Hindu newspaper analysis of 5th January 2018. This is the first page of Hindu newspaper, and this page contains one important article, and the article is discussing about the triple talaq issue. That is, this article is discussing about the Muslim women's protection of rights on marriage bill. We have already covered in detail regarding this bill in our previous video lectures, and for those of newcomers, do download our official Android app and learn it from there. So now let us move on to next page. This is page number 2 of Hindu newspaper, and this page contains one important article. This article is very much important from the perspective of General Studies paper 3 of UPSC Civil Services examination, because this article is discussing about the avian population. We know that the state of Odisha is known for the bird watching, because the state of Odisha is having some of the important national parks and bird sanctuaries in India. Some of the important national parks and bird sanctuaries which were located in Odisha were the Simplipal National Park, the Bhitarkanika National Park, and the bird sanctuary adjacent to the Chilika Lakes. In such scenario, recently the bird survey have been carried out in this region, and it has been found out that the number of birds which were living in this region is considerably less according to the census. In general, the birds which were visiting the Chilka Lake or the Odisha state is primarily coming from the nations like Russia, especially the birds will visit from Siberia, Caspian Sea, and the bird will also visit from the Lake Baikal. In such scenario, the migratory bird count is considerably reduced this year. The main reason is, this year we are having a good monsoon rainfall. As a result, majority of the mud land were filled with water, and also the green cover have been considerably increased in the region surrounding the Odisha state. And due to the abundant growth of high grass and other vegetation and also increase in density, the survey makers were unable to spot the bird exactly, because many of the birds were hiding behind the dense vegetation. So as a result, the count which were submitted by the Forest Division in the survey is considerably reduced. That is the reason which is stated or provided for the sighting of less number of migratory species in Odisha. Apart from carrying out the migratory bird survey or migratory bird census in the 37 large water bodies of Berhampur Forest Division, the survey or bird census is also carried out in the Simplipal National Park as well as in the Bhitarkanika National Park. The state of Odisha, in order to boost the tourism, it has projected the National Bird Festival this year. And that is what all provided in this article. And now let us move on to next page. This is the page number 6 of Hindu newspaper, and this page contains one important article. This article is very much important from the perspective of UPSC Civil Services Mains examination, because this article is discussing about the child marriage issue. In India, we are having the Prohibition of Child Marriage Act of 2006. Even though we are having the Prohibition of Child Marriages Act of 2006, the India is still witnessing around 3,600 child marriages every day. That is, roughly around 40% of the world child marriages were happening only in India. In this scenario, recently, the National Family Health Survey 4 have found out that 26.8% of the women who were aged between 20 to 24 years have stated that they have been married below the age of 18. And the child marriage is most predominant in 6 major states of India. The 6 states are Odisha, Assam, Bihar, Chhattisgarh, Jharkhand, and West Bengal. Among these 6 states, the top 2 states were the West Bengal and Bihar. In West Bengal, roughly around 40.7% of the women have stated that they have been married below the age of 18, whereas the ratio in Bihar is 39.1%. So in order to curb this child marriage issue, recently the National Human Rights Commission have directed the state government to make some certain efforts to curb this social menace. Accordingly, the regional conference have been held between the National Human Rights Commission and the 6 state administrators. Accordingly, the first meeting is recently happened in Bhubaneswar, that is in Odisha. In this meeting, the factors which were responsible for the child marriage is discussed, and apart from that, the practice to eliminate this child marriage is also discussed in this meeting. Accordingly, the National Human Rights Commission has finally stated that the awareness have to be created regarding the health risk due to the child marriage, and the National Human Rights Commission has also emphasized on the education and skill development for the girl child, because only then the girl child can be employable in future. That is what all provided in this article, and now let us move on to next page. This is the page number 7 of Hindu newspaper, and this page contains 2 important articles. This is the first important article of this page, and this article is very much important from the perspective of General Studies Paper 2 of UPSC Civil Services Mains examination. The main reason is this article is discussing about the human rights codes. Recently, it has been found out that some of the orphanages in India were trafficking the children who were under their care. So, in order to protect the dignity of the child, the Supreme Court of India has stepped up and made some observation in this regard. Accordingly, the Supreme Court has observed 2 important points. The first point is, it has stated that the person who have found guilty of trafficking the children were supposed to be punished. And the second observation is, it has stated that such kind of a trafficking amounts to the violation of human rights. These are the 2 important observations which is made by the Supreme Court of India in this regard. After providing these 2 observations, the Supreme Court of India has highlighted that the Human Rights Law of 1993 makes the state government responsible for setting up an exclusive human rights court with special public prosecutors in every district. But until now, none of the states have created such kind of a human rights court. So as a result, now the Supreme Court of India has questioned all the 25 states in India, and also it has demanded the response in this regard within 2 weeks of time period. So, it has been expected that in future there will be a exclusive human rights court will be available in every district in every states. That is what all provided in this article, and now let us move on to next article. This is the second important article of this page, and this article is very much important from the perspective of General Studies Paper 2 of UPSC Civil Services Mains examination, because this article is discussing about the Sexual Harassment of Women at Workplace Act of 2013. Before getting into details of this article, first let us see what is meant by Visakha case judgment. Actually, the Visakha case judgment is delivered by the Supreme Court of India in the year of 1997, and this Visakha case judgment has acted as a guidelines for treating the issues like the sexual harassment of women at workplaces earlier. This Visakha guidelines is provided by the Supreme Court of India with a view of 2 important concepts. The first concept is the international conventions, and the second concept is the spirit of gender equality which is enshrined in the Constitution. Here, the gender equality includes the protection from sexual harassment as well as it includes the right to work with dignity. Here, the right to work with dignity is a universally recognized basic human right. After the delivery of this judgment by the Supreme Court, the Union Government has decided to enact a law in this regard. Accordingly, the Union Government has come up with a Sexual Harassment of Women at Workplaces Prevention, Prohibition and Redressal Act of 2013. It has some set of rules which is dealing with the issue of sexual harassment of women at workplace. Even though this act has been enacted in the year of 2013, but still it is not implemented effectively. That is, many of the state government has not even taken sufficient amount of steps to address this issue of sexual harassment of women at workplace. Some of the government has not even appointed the district officers or local committees according to this Act, and there is no appointment of nodal officer or internal compliance committees were taken place in certain offices, and the government have not taken any kind of move to ensure the reporting and collection of annual compliance report from the workplaces. So the implementation of the Sexual Harassment of Women at Workplaces Prevention, Prohibition, Redressal Act of 2013 is not yet done effectively. So in order to address this issue, the women's rights activists were filed an public interest litigation in the Supreme Court in this regard. So let us hope in future the effective implementation of this act will take place. And that is what all provided in this article. And now let us move on to next page. This is the page number 10 of Hindu newspaper, and this page contains two important articles. This is the first important article of this page, and this article is discussing about the bill to hike the salaries of the Supreme Court and High Court judges. Recently, the Lok Sabha, that is lower house of the parliament, has successfully passed a bill to hike the salaries of the Supreme Court judges and High Court judges. According to this bill, the salary have been classified into three slabs. The first slab is having the salary of Rs 2.80 lakh a month for the Chief Justice of India, and the second slab is having the package of Rs 2.5 lakh a month salary for the judges of Supreme Court and for the Chief Justice of High Court, and the third slab is having the salary package of Rs 2.25 lakh a month for the judges of High Court. This bill is passed by the lower house of parliament to give effect to the 7th Pay Commission regarding the pay hike of the Supreme Court and High Court judges. And it has been stated that this pay hike will come into effect from the January 1 of 2016. And during the discussion of this bill, some of the important issues of the judiciary were also discussed. Accordingly, two important issues have been discussed. The first issue is regarding the creation of the All India Judicial Service. This All India Judicial Service is likely to be created in the lines of the Indian Administrative Service. This All India Judicial Service is meant for the drawing of the best legal minds in the judiciary. That is the one of the proposal which is under the consideration of the Union Government of India. And the Union Government has also discussed regarding the failure or cancellation of the National Judicial Appointment Committee. Earlier, the Supreme Court of India has cancelled the National Judicial Appointment Committee. The Supreme Court has stated that the separation of power is the core of the Constitution of India, and accordingly, the Supreme Court cannot allow the legislative to interfere in the judicial activity. That is the reason which is stated by the Supreme Court for cancellation of the National Judicial Appointment Committee. Because in National Judicial Appointment Committee, the Law Minister is also a member. So as a result, the legislative is interfering in the activity of judiciary. Since the National Judicial Appointment Committee is classified as void, now the Supreme Court's collegium is the recruiting body which recruits the judges for the judicial wing. In such scenario, the collegium will recommend the names of judges to the government, and only those judges will be appointed for the Supreme Court or High Court. And at present, there are around 6 vacancies were available for the Supreme Court judges, and as well as there were around 269 vacancies were available for the High Court judges. So the Union Government has recommended the collegium to fast up its process in recruiting all these judges, because the judicial wing is already overburdened with a lot of cases. So in order to effectively solve all those cases in time-bound manner, the effective strength of the judges is need of the hour. And those are the important discussions which were going on regarding the judiciary in Parliament, and that is what all provided in this article. And now let us move on to next article. This is the second important article of this page, and this article is very much important from the perspective of General Studies paper 1 of UPSC Mains examination, as well as from the perspective of the preliminary examination. Recently, the 75th anniversary of the Quit India movement is celebrated in the state of Tamil Nadu. So in this background, it is very much important to know about the Quit India movement. The Quit India movement is also known as the August India movement. This movement is launched by the Mahatma Gandhi on 8th August 1942. Earlier, the Cripps Mission have failed the demands of the Indian Congress Committee. As a result, the Gandhi has provided a famous statement, that is do or die, in his Bombay session of All India Congress Committee and launched this Quit India movement. After the announcement of the Mahatma Gandhi, the entire Indian National Congress Committee as well as the entire India Congress leaders were well prepared to organize a mass scale movement. But unfortunately, the British were well prepared in this regard and they have arrested all the major leaders of the All India Congress. As a result, the Quit India movement is carried out with less number of leaders in the field. And for further information regarding the Quit India movement, do download our official Android app from Google Play Store. That is what all provided in this article, and now let us move on to next page. This is the page number 11 of Hindu newspaper, and this page contains one important article. This article is discussing about the recent procurement of the defense industry. Recently, the Ministry of Defense have announced for the two capital procurement for the Indian Navy and the Indian Army. The two procurement were number 1, the P-81 training solution, and number 2, the low intensity conflict electronic warfare system. Here, the P-81 training solution is brought for the Indian Navy. This P-81 training solution will provide the accurate simulation of the P-81 aircraft and mission system. By having this training solution, the Indian Navy can be able to train realistically the sophisticated mission, and also it will reduce the fraction of the cost of live aircraft training. Apart from that, at present, the India is having around 8 P-81s which is operated via the INS Rajali. In this scenario, the Indian government is also ordered for 4 more P-81 and it will be delivered to India starting from the year of 2020. This is all about the first procurement, and the second procurement is the low intensity conflict electronic warfare system. This low intensity conflict electronic warfare system is brought for the Indian Army, and it is brought or procured from the Bharat Electronics Limited at the cost of Rs 470 crore. And this system will be very much helpful for the Indian Army to deal with the advanced communication system which is used by the terrorist. And that is what all about this article. And now let us move on to next page. This is the page number 13 of Hindu newspaper, and this page contains one important article. This article is very much important from the perspective of General Studies paper 3 of UPSC Civil Services examination. And this article is discussing about the recent announcement of Union Government for the introduction of the new saving bond. In this article, we are going to see about some of the salient features of this new saving bond. This new saving bond will be having the interest rate of 7.75%, and this bond is one of the taxable instrument, and there is no monetary ceiling is present for this savings bond. This instrument will be available for sale starting from the January 10th of 2018. For buying this new savings bond, the eligibility condition is it is open to all the individual joint holdings and the Hindu undivided family, but only restriction for purchasing this saving bond is it is not available or not acceptable for the non-resident Indians, which means the non-resident Indians were not eligible to buy this bond. This taxable saving bond will be taxed under the Income Tax Act of 1961 as applicable according to the relevant tax status of the bond holder. But you have to note down, this new taxable saving bond is exempt from the wealth tax under the Wealth Tax Act of 1957. Apart from that, this new saving bond is not transferable and also it is not tradable in the secondary market. Apart from that, this new saving bond is not eligible as a collateral for any kind of loans for banking institutions, non-banking financial corporations as well as financial institutions. These are the important points of this new saving bond scheme. And one important point you have to note down, if suppose you are investing ₹1000 in this saving bond, then at the end of 7 years, that is the threshold time period, at the end of the 7 year, you will receive the amount of ₹1703. And that is what all provided in this article. And now let us move on to next page. This is the page number 9 of Hindu newspaper, and this page contains 2 important articles. This is the first important article of this page, and this article is discussing about the Negotiable Instrument Amendment Bill of 2017. We know that at present the Union government is pushing towards the Digital India scheme, and also the Indian economy is moving towards the cashless economy. So in this scenario, the Union government is looking forward to strengthen the other instruments of the financial transactions, that is the check transaction. We know that in check transaction, the check bounce is the one of the biggest issue, and whenever the check bounce is happened and the case is filed in the court, then the check bounce case takes a long time to solve. So as a result, the victim of the check bounce case is always lost the hope and thereby he completely withdrawn from the case. That is what's happening in general. So in order to avoid these sort of hurdle to the victim, the Union government has come up with 2 new sections which is likely to be included in the Negotiable Instrument Bill of 1881 Act. The 2 sections were, number 1, the section 143A and number 2, the section 148. According to the section 143A, the court can order the drawer of check to pay the interim compensation to the complainant at the time of framing of charges. Here you have to note down, the interim compensation have to be around 20% of the amount of the check. It should not exceed the 20% threshold limit. That is the first new section which is likely to be included in the Negotiable Instrument Bill of 2017. And the second section is section 148. This second section allows the appellate court to first order the party convicted in a check bounce case to deposit the 20% of the fine or compensation which is awarded by the trial court. These are the 2 important sections. By including these 2 sections in the Negotiable Amendment Act of 1881, the check bounce cases can be considerably reduced and the problem of the check bounce can be drastically brought down. That is what all provided in this article. And now let us move on to next article. This is the second important article of this page, and this article is very much important from the perspective of General Studies Paper 2 of UPSC Civil Services Examination, because this article is discussing about the judiciary as well as it is discussing about the legislative. Here the question is whether the legislators, that is the MPs and MLAs, can be allowed to act as a lawyer in court. That is the question. For this question, many of them were saying that the MPs and MLAs should not be allowed to participate in the court proceedings. That is, MPs and MLAs were not allowed to be lawyers in the court. That is the contention of some of the people, and for this contention some of them were opposing. These are the 2 sides of the coin. First, let us see what are the reason which is put forth by the people who were asking to bar the legislator to be practice as a lawyer in the court. The first case is, according to the Rule 49 of the Bar Council of India, it has been stated that the full-time salaried employee, whether he or she is belong to a corporation or a private firm or government, cannot be able to participate as a lawyer before the court of law. It is given in the Bar Council of India rules. In simple terms, it means no public servant can be able to act as a lawyer. That is the simplest definition of what is given in this rule. But since the MPs and MLAs were considered to be a public servant, the MPs and MLAs should not be allowed to be a lawyer in the court. That is the first contention. You may have the question like whether the MPs and MLAs were coming under the public servant or not. For this question, the answer lies in the verdict of the M. Karunanidhi vs. Union of India 1979 case. In that case, the judiciary has clearly stated that the MPs and MLAs are the public servants, though the employer and employee relationship will not apply to them. This is clearly stated by the judiciary itself. So, the MPs and MLAs were also considered as a public servant and hence they should not be allowed to be a lawyer. That is the major contention which is put forth in this regard. Second reason is the lawyer profession is considered to be a full-time activity. Likewise, the legislative action is also considered to be a full-time activity. So it has been argued that the legislator have to act fully in the regard of the public service and they don't have to come to the court to act as a lawyer. That is also one of the valid point which is put forth. Because in India, the people were in demand of the legislator to solve their problem. So in India, we don't want the part-time legislator to be present in the parliament or in state legislature. That is also one of the valid point which is put forth. And also, it has been stated that some of the MPs and MLAs who were acting as a lawyer were fighting the cases in favor of the third party, that is in favor of the business industry against the government. So it contributes to the violation of the moral conduct, that is it is a professional misconduct. So it is also one of the issues which have to be addressed. So these are the three important valid points which is put forth by the people who ask to ban the participation of the legislator to act as a lawyers. For these three questions, the people were also answering effectively. The people who were asking to allow the participation of the legislator to act as a lawyers were stating that in general, the parliament is combined with the people from different professionals and one such professional is what? The lawyers. The parliament is filled with the professionals from the medicine, that is doctors were present in the parliament. Similarly, some sports persons were present in the parliament. Similarly, the film actors and actresses were present in the parliament. Similarly, the various writers were present in the parliament, and in such scenario, what is the wrong with having a lawyer to be a legislator? That is the first question or valid point which is made in this regard. And the second is, in general, the people always allot time according to the priority. So, the legislator who can both be a function as a legislator as well as he can function as a lawyer. That is also one of the valid point which is put forth. Apart from that, it has been stated that for being a public servant or a social worker or being in politics or doing some civic duty, we don't need any kind of qualification. So, the lawyer can be a person of civil servant as well as he can do any kind of social work or civic duty by both being a lawyer as well as following that own profession. So these are some of the valid points which is put forth. So at present, the Bar Council of India have to find what is the final result in this regard, because Bar Council of India have to look forward the important provisions of the constitution like the equality of the profession. We should not discriminate the lawyers from other profession. So as a result, the right to equality is in question. So there are a lot of issues were going around this one question, and we hope that the Bar Council of India will find a proper answer for this problem. And that is what all provided in this article. And now let us move on to next page. This is the page number 8 of Hindu newspaper, and this page contains 3 important articles. The first article is discussing about the Bhima-Goregaon battle. The Bhima-Goregaon battle is held in the year of 1818 and it is fought between the army of Peshwa with the army of British. It is one of the part of the Anglo-Maratha war, and we have already discussed a lot regarding the Bhima-Goregaon battle. So now let us move on to next article. The second article is discussing about the triple talaq issue. Recently, the Supreme Court of India has banned the practice of the instant triple talaq, and even after banning the practice of triple talaq is still followed in some of the states. So in order to curb this practice completely, the Union government has come up with a new law in this regard, and the law is called as the Muslim Women Protection of Rights on Marriage Bill of 2017. Right now this bill is in the parliament and we have covered a lot regarding this bill. So now let us move on to next article. The third article is related to the US Fed. Since we are not having sufficient amount of time to discuss all the 3 articles, we kindly request you to go through these 3 articles on your own. Now let us move on to next. That is for all about the today's video lecture on the Hindu newspaper analysis of 5th January 2018. For further important video lectures and notes regarding the UPSC Civil Services examination, do download our official Android app from the Google Play Store. All the best for your future examinations. Thank you.